Continuing with the calendar, page 23, House bills on second reading regular calendar. House Bill 791, a bill to amend and reenact sections of the Code of Virginia relating to the Condominium and Property Owners Association Act's rule enforcement. Report from the Committee on General Laws with a substitute.
The gentleman from Fairfax, Mr. Lemunion.
Thank you, Mr. Speaker. I move adoption of the committee substitute.
Mr. Speaker.
The gentleman from Fairfax, Mr. Surovell.
Parliamentary inquiry, Mr. Speaker.
I may state it.
Mr. Speaker, this bill, when it was originally introduced, was very narrow and only had a few words in it that was adding to the code. It was solely focused upon, only focused on saying that a homeowners association could go to a general district court instead of a circuit court to enforce a rule violation. The committee substitute added a lot more language and words to it. It also, Mr. Speaker, on lines 30 through 31, completely flipped the presumption with regard to the powers that homeowners associations are entitled to exercise. It said that they're allowed to exercise powers in the statute unless the homeowner's contract prohibits it, which is a significant change to Virginia law, which was not in the original bill. The public was not on notice of that. It didn't even hit LIS until this thing hit the floor after it was approved by the committee on Monday. And I would ask you, Mr. Speaker, whether or not the committee substitute is therefore not germane under Rule 62A, which states that no motion or proposition or subject different from that under consideration shall be admitted under color of amendment.
The question has been brought to me already, and the original bill gave the Property Owners Association the right to file a legal action for an order of abatement as a separate remedy for rule violations. The committee substitute adds an additional avenue of remedy for appeal and does not, in my opinion, stray from the original intent of the bill. And so I'm going to rule that the substitute is germane.
Thank you, Mr. Speaker.
The questions on adoption of the committee substitute, as many as favor that motion will say aye.
Aye.
Those opposed, no. The substitute is agreed to. The gentleman from Fairfax.
Thank you, Mr. Speaker. Mr. Speaker, ladies and gentlemen of the House, the bill amended by the substitute pertains to enforcement of rules by homeowners associations. And the principal purpose of the bill is to make it less likely that disputes between association boards and homeowners will end up in court. It does that really in two ways. One, we add a no surprise rule to the code that says that if an HOA board wants to enforce rules, they can't surprise someone, slap them with a sudden lawsuit. They have to give the homeowner due process in the form of notice, opportunity for a cure, for a hearing, additional notice, a response, a process that could probably go a few weeks, if not a couple of months, before the statutory maximum fine of $10 a day might be imposed on the homeowner, or that they might lose their rights to use a swimming pool or a tennis court, for example. It also addresses one other issue in the code, and that's where the homeowner association documents don't give the board explicit authority to do the things that I just said. So in that case, where the documents are silent, that homeowners association could do the same thing. They would have to go through the due process procedures and only thereafter could impose the $10 a day fine or suspend someone's privileges for use of a common area. I think it's a very fair and even-handed approach to making sure that we keep these kinds of disputes out of court. The reason I'm really enthusiastic about this, Mr. Speaker, is a conversation I had with a woman in my district when I was knocking on doors back in October, and she's in her 60s. She owns a townhome. She'd like to sell that in the next year or two. She's in an HOA, and I came to her door and she said, look down the street. There's a couple of guys that own townhouses down there. They're dilapidated. Unfortunately, our homeowners association can't enforce the rules. Going to court is a really expensive proposition, but it's going to cost me tens of thousands of dollars in my equity that I need for retirement when I decide to sell these things, and she'd want something done about it. My effort to do something about it is House Bill 791, and I hope it would be the pleasure of the body to engross the bill and pass it on to its third reading.
Gentleman from Fairfax, Mr. Surovell.
Will the gentleman yield for a question?
Gentleman yield.
Mr. Speaker, it would be my pleasure to yield.
Gentleman yield.
Thank the gentleman from Fairfax for yielding. The situation you just described, this is the neighbor who is unhappy with their other neighbor. Without your bill, isn't it true that under existing Virginia law, they could actually bring an action against their fellow neighbor for not complying with your homeowners association documents?
I believe it's true, as I mentioned, that they would have to go to court, and that's an expensive proposition, at least for that homeowners association, that they'd prefer to avoid, but they don't have any preliminary ability to slap on a $10 a day fine or otherwise suspend their privileges as an intermediate effort of maybe correcting the problem.
Mr. Speaker, the gentleman yield for another question.
The gentleman yield.
My pleasure to yield, Mr. Speaker.
Still his pleasure.
So it's the gentleman's intent to try and make it easier for one homeowner or for another homeowners association to tell another property owner what to do with their home or their land. Is that a fair statement?
Mr. Speaker, I would say to the gentleman, only when it's clear in the view of that board that the homeowner is in violation and subject to all of the new due process procedures in the rule that in the bill that would provide notice, an opportunity to cure, a hearing that would take several weeks, which hopefully in that period of time the problem would be resolved.
The gentleman yield for an additional question.
Gentleman yield.
I'll yield for another question, Mr. Speaker.
Gentleman yields. He's not as happy as he was initially.
Thank you, Mr. Speaker. So, just so I'm clear about this process you envision, suppose I live in one of these homeowners associations, which I do not, and I do that intentionally. Not so many people can choose to do that, given many new homes, or all new homes almost today, are almost all in these things. But suppose, for example, I was living in this homeowners association and the board didn't like me. Can you believe that?
If the gentleman's going to use hypotheticals, make them believable.
Okay. Ayes and nays? No? Okay. Thank you, Mr. Speaker. Now, suppose this board, suppose they didn't like the fact that I had a Tea Party flag hanging on my front door.
There you go again.
Okay? And suppose the board decided to adopt a rule, which this applies to ban flags from the community, including American flags. That's right. Now, Mr. Speaker, Mr. Gentleman, isn't it true that this bill would give my neighbors who don't like me and don't like my flag the authority to fine me $10 a day until I take my flag down?
Mr. Speaker, I would say to the gentleman, it's my understanding that the majority of homeowners associations today have their rules crafted in a way that actually could allow that to happen today. Would point out to the gentleman that these HOA boards are elected, and so if they're acting in some sort of frivolous or bothersome manner, you can throw the guys out. But there's actually a specific protection we put in the bill explicitly stating that they can't behave that way. And that's one of the protections in our no surprises clause that we've added.
Will the gentleman yield for another question?
Gentleman yield.
Mindful of the body's time, Mr. Speaker, I'll yield for one more question.
Gentleman yields.
Thank you, Mr. Speaker. I was reading this bill, and some of this language added in the committee substitute said, I guess it's line 40 through 42. The powers, this is new language, the powers authorized in this section by the condominium instruments shall be exercised by the Unit Owners Association in good faith and not exercised frivolously, vexatiously, or primarily for purposes of harassment of the unit owner. So is it the gentleman's intention that if my secondary intention is to harass, that's okay?
Mr. Speaker, I'd say to the gentleman, I'm not sure what the import of his question is. I think those words are explicitly clear that that's not what the homeowner association can do, and we put them in there because, in fact, there has been some evidence of boards behaving that way, and we're making it clear that that's out of bounds.
Speaking to the bill at the appropriate time, Mr. Speaker.
Gentleman has the floor.
Thank you, Mr. Speaker. Mr. Speaker, I want you to close your eyes. I do. Mr. Speaker, I want everybody in the body to close your eyes. And I want y'all to imagine that you went out and you bought a home. You bought this great new house. You're all excited to move in. You move in. And no, I'm not there. I'm sitting on the board of directors, along with my colleagues, Director Morrissey and Director Corey.
I can see where this is going.
Yeah. And Mr. Speaker, you decide to put a sign in your front yard, exercising your First Amendment right to tell people who you are going to vote for in an election. And I want you to suppose that a few weeks later you learn that the association has adopted a rule saying that you got to take down your sign because they don't like it. What this bill does, Mr. Speaker, is it gives that board of directors the authority to fine you $10 a day. If you don't pay it, take that fine, put it as a lien on your home. You don't pay that lien, foreclose on your house without the involvement of a single court. Go read it. Go read the lien statute. And it says that assessments or fines can be converted into liens, and that's what it does. Mr. Speaker, let me talk about the history of this and how this bill got here. This statute was adopted, go back and look it up in LIS, in 1997. If you read the language, Mr. Speaker, what the bill says right now, what existing law says that got changed by the substitute, which I argued was not germane, but what it says is the unit owner association shall have the power to the extent the condominium instruments or the homeowner's instruments expressly so provide. That's what the original statute adopted in 1997 said, that if your contract says you can have the power to fine, then you can exercise the power to fine. Mr. Speaker, I had a family that came to me a few years ago. They had a sign in their yard for the president at the time he was a candidate. And some of the people on their board didn't like their sign. Mr. Speaker, and they sent my clients a letter telling them to take down their sign because they had a 3-foot by 3-foot sign rule. So my clients cut their sign in half. They had one sign that said Oba and another one said Ama. And the board didn't like that. So about 3 months later, the board went and consulted a lawyer, and they adopted new rules saying that instead of having to go to court, which is how they'd been operating since 1965 in that community, 1968, the board, without going to the homeowners, without having a meeting, without changing their bylaws, had given themselves the power to levy fines on homeowners that didn't follow their rules. They called me, and about $400,000 of attorney's fees later, not spent all on me, and about a year and a half of litigation, 5 days of trial, a Fairfax County Circuit Court said that Homeowners Association had exceeded the power in their covenants, and it exceeded Virginia law by giving themselves powers that Virginia code didn't authorize them to give, and that the homeowners by contract did not authorize that board to exercise over their home and how they live their life in their home. The judge issued a written opinion. It went out across the state. The Homeowners Association industry went crazy because they all thought they could give themselves all the powers they want. So then it started getting litigated in courts all around Virginia. And there was one decision out of Loudoun which went the other way, and there was another decision out of Loudoun that agreed with the decision in my client's case. That case was appealed to the Supreme Court of Virginia, which agreed with the judge in my client's position that a homeowners association cannot take powers from its homeowners unless their contract specifically says they can do it. And that's because, Mr. Speaker, that is the law of this state. It's been a law of this state all the way back to England. The common law, ladies and gentlemen, of Virginia is that when you have a contract that restricts property rights, when you have a contract that restricts how somebody can use their land and use their home, I'm quoting from a decision of Schwarzschild v. Wellborn, 1947, Supreme Court of Virginia. They are to be construed most strictly against the grantor and the person seeking to enforce them, and substantial doubt or ambiguity is to be resolved in favor of the free use of property against restrictions. That's the law of our state, and that is why the statute reads like it does. And Mr. Speaker, this bill turns all that on its head. Because what it says is that unless your contract has a prohibition in it, unless your contract says you cannot have the power to fine, you do not have the power to regulate the height of grass, you do not have the power to tell somebody what color to paint their shutters, you do not have the power to tell somebody when they have to take their trash can back in, then the General Assembly can give them all these powers. That's what this bill says. And back in 1965 or 70, 1980, when lawyers were drafting documents for these communities, they weren't thinking about all the various powers we were going to be giving these bodies, because that isn't what the law of this state is. And what this bill does is it enables the bullies in the community. It enables these people that want to pick on their neighbors. It enables people that want to tell people what to do on their land. Mr. Speaker, John Marshall, Chief Justice from Fauquier County, he wrote, "The power to tax is the power to destroy." And I would submit the power to fine is also the power to destroy. The reason they want this power is because it's a whole lot easier just to levy fines every day against somebody than it is to take them to court to get a judge to agree with you to tell them to do something with their land. That's why the HOAs want this power. This is a power grab. Make no mistake about it. How many people in your community have come and said, my homeowners association? How many of your constituents have said, how many of my homeowners associations don't have enough power? Make it easier for them to tell me what to do. I'd be shocked if a single person here, aside from Delegate LeMunyon, I guess, who had one person knocking doors because she wanted to sell her home, wanted that. But how often has that ever happened? Mr. Speaker, I would submit that as long as that flag stands on your right and 6 Semper Tyrannis stands on your left, and I know it's on your left, the rights guaranteed by the Virginia Declaration of Rights for people to do with their property what they want are superior. And we should honor those rights, Mr. Speaker. We should vote down this bill. Thank you, Mr. Speaker.